the ones, the 8, I assume they are in, or the 8 and the other 4 would be in office until their replacement is made, just like it was through the Supreme Court decision? Because they held something that never existed before. Usually a vacancy is a vacancy. This case, well, they were vacant, but they weren't vacant, which they kind of wrote new law. Would it be opinion that they would be in office in their acts all valid until their replacement is sworn in? We then have other people in office too.
No. You would go back to, for the purpose of the redo, for the purpose of that meeting, you would go back to the way we were at 9 a.m. on January 31. That meeting would be conducted, appointments would be made, those persons would be sworn and take office.
And all those individuals who would vote, there would be no correspondence or lead to what we call deliberation from the time this decision is made by the commission until they meet. So all their discussions are in the sunshine.
I think they would need to comply with the sunshine law.
Thank you.
Commissioner Hammond.
Thank you, Mr. Chairman. I'm not a member of this committee, but I appreciate the opportunity of speaking. I have been on a legislative committee and have been to Nashville 3 times with regards to the Open Meetings Law and the Sunshine Act, and I will tell you that there are differences of opinion with regards to what a violation consists of. For example, must you have a quorum in order to violate the Sunshine Law? That's an issue. Another issue is it 2 or more? There are differences of opinion on that. One thing that is clear is that commissioners can talk. No one disputes that. The issue is, have they discussed things toward a deliberation? Have they discussed things that would lead you to believe that they have reached a conclusion outside of an open meeting? The only evidence that I see that has been presented with regards to a violation of the Sunshine Law is what we have seen in the newspapers. And that is up again for interpretation. My personal feeling is that without a lack of evidence, we really have nothing to act on. It would appear to me that a judge would need to come and tell us that we have violated the law. I have no problem giving a deposition. I have no problem in going in front of anyone, public or private, to explain any action that I took, and I'm only speaking for myself, but there has been no concrete evidence presented that I'm aware of that would indicate a violation of the Sunshine Law. Now, that may come out in discovery. That may come out in deposition. A judge may come in and discover that he has done that. The other thing I'd like to point out is that I believe at some point we do need to have discussions with our lawyers, and I'm very pleased to see that the News Sentinel has dropped us as individuals. I had already contacted legal counsel to represent me as an individual. I will tell you it's not cheap, and I can tell you that not a lot of people want these jobs if they're going to be sued as an individual for any action that they take. So I'm pleased to see that. But I would point out, and my last point is this, Mr. Chairman, that if we do meet an executive session or if a number of people, the onus is on the law director to make sure that the law is followed. He could lose his license, and he could be severely censored if he veers off course and if he does not follow the very strict guidelines with regards to an executive session. So at some point we may want to consider that, but just understanding that it is strict, but I'm sure that the law director is going to make sure that we don't violate any law that would create any problems down the road.
We have executive sessions with the Board of Education, for instance, quarterly. And my counsel to them has always been, if you decide you're going to talk with each other, then I become a very rude person, and tell them so. And ultimately, if they were to decide to talk with each other, then I would leave the room. And that doesn't occur. They're very good about listening to their counsel, and in my discussion with them about our pending legal matters, they're very good about it.
Commissioner Harmon.
I would just add that
I think the law director has been quite clear that the advice that he will give is the advice that he's presented here publicly. So I don't see a need to, if other people feel a need to go in and chat with him, that's fine. But I think we would set a bad precedent if we relied too heavily on out-of-public site meetings to resolve the matter of whether we have abused the privilege of out-of-site public site meetings. I think that's really a troublesome idea. I think that's why I disagree with Chairman Moore's suggestion that we drop this matter, and I agree with my original motion that we take it up without recommendation at the next county commission meeting and simply discuss it in public view, whether we want to accept this offer or offer a counteroffer or do nothing at all. That seems the appropriate remedy.
I understand where you're coming from, Commissioner Harmon. I'm curious as to how we come with a counteroffer without having, for myself, having discussed what possible counteroffers there could be with the law director, because I don't know what would be permissible, what wouldn't, and what are the ramifications, and I would want the ability to talk to.
I think that would be an appropriate individual use of you visiting our attorney on this matter.
Yes,
law director.
A couple more questions.
Ballot.
You know, when you talk of evidence and stuff, it doesn't always come out during depositions. If I have an attorney representing me, such as John, I believe is going to take on the entire representation, definitely a key part is, has anyone violated the Sunshine Law? Now, some of us are new, may have done it unintentionally. Some of us may have got lax. Some of them may have followed the letter of the law, but I can't pretend to keep up with 19 members here. And if Mr. Owens met one-on-one and they can tell him their actions and he can say, well, you did or you didn't, and then we met in executive committee and say, look, I've talked to all of you. There's been no violations of the Sunshine Law, or I've met with 19 of you, and 7 appears to be clear. I doesn't need any judge help in that. That would be certainly key information for this whole body to consider, whether we would want to accept any plea bargain, accept it as is, or fight it all the way. But I understand how we can, without a little of that information, John, which would be privileged one-on-one, would it not, John?
It would, and I've given a lot of thought to that.
My next.
All right.
Say, after talking with the individual, he doesn't feel like that he's violated the Sunshine Law, and you do. Does that represent a conflict in which he would have to obtain his personal then?
No. I represent the governmental body of Knox County. As a commissioner, you are part of that governmental body. You would only be sued in your official capacity, and so it would not present a conflict.
How do you go forward if you think he has and he thinks he hasn't?
I tell the person who is to be deposed to tell the truth and tell what it is that occurred with them, whatever discussion they may or may not have had, and to answer the questions. And we deal with the facts that are brought us.
Do you not feel the most comfortable by meeting with people one-on-one to see if they have violated the Sunshine Act? Maybe they don't know that they
I don't think I would feel comfortable hearing that anyone violated the Sunshine Act. If what we have here is an offer. We have an offer from